Okay, I think we're recording there. And Jean is having a little bit of technical difficulties with her video, but that shouldn't be too much of an issue. I'm going to run the slides and we should be good to go. Jean's expertise in archives and the impact of law on archival practice has been developed over many years of experience as an archivist in the government, education, and nonprofit sectors. In Canada, she is currently a consultant and educator in Toronto. Her consulting practice encompasses the domains of copyright, records management, and archives, including training, needs assessment, and policy and procedure development. In 2015, she completed a Master of Laws degree in intellectual property at Osgoode Hall Law School at York University. And we're really excited to welcome her to the community chat today. And she's going to be speaking about copyright basics for museums. And of course, it's a large ask to do in such a short amount of time, but thank you for agreeing to come on to the chat, Jean. And I will get your slides up here.
Okay, well, thank you very much, Em. And good morning, everybody. And I'm speaking to you from Toronto, where it is in fact just afternoon. And Toronto, I'm speaking to you from the traditional lands of the Huron-Wendat, the Haudenosaunee, and the Mississaugas of the Credit. It's probably just as well that you can't see me because I just got off the train from Stratford. And the train is always late, but this one was really cutting it a little bit too fine for my taste. And but anyway, I made it on time. But I am looking a little harried, so just as well you can't see me. So I can't see the slides, but
okay. Wendy, can you see the slides there?
Yes, I can.
Okay.
Yeah, it's the introductory community with the name.
Yeah, it's a you know the cover sheet, if you will.
Uh-oh. Oops. Jean, we cannot hear you, or I can't anyway.
Nope, can't hear.
Okay, Jean, are you there?
Anyway, maybe that's part of the video. Anyway, yeah, hello, yes.
Okay,
Hello.
good.
Got ya.
Yeah. Okay, maybe that's part of my video problem is I can't see the slides. But anyway, if you could go to the second slide, which is the outline.
You bet.
And we're, obviously we've got a very limited time here. And so we can't do much more than skim lightly over the copyright waves, but here's what we're going to cover. I want to talk first about why copyright's important for cultural heritage institutions. And then I want to give you, spend most of the time on an overview of how the Canadian Copyright Act works. And at the end, we'll have some time for questions. So my first, and there's no slide for this, so it's okay, you can leave it on the outline. I want to talk a bit about why copyright is important for cultural heritage institutions. And if you think about, my background is archives, but the Copyright Act groups libraries, archives, and museums together in one group as cultural heritage institutions. So if you think about all the times you copy stuff from your collections, you realize that copying and thus copyright is an issue. So you may be making copies of fragile documents in order to preserve the original. You may be digitizing documents so that you can make them available online. And you will probably be making copies for exhibitions because you don't want to display the original if it's the only one you have. And if you have some archival holdings, you know, most of you, I'm sure, have photographs and you know, maybe things like scrapbooks and whatnot. If you have documents, you're probably making copies for researchers. So you can see that copying plays a large part in how cultural heritage institutions fulfill their mission. So if we could have the next slide, please, the what is copyright slide. And copyright is, in fact, a balance. The copyright law, you know, copyright law gives copyright owners certain exclusive rights that allow them to control the uses of their works, you know, uses of what they've created, and also, one hopes, to be paid for the use of those works. But the balance part
Uh-oh, I think, I don't know.
the
Yeah. Sorry, Jean, you just cut out there for a minute. I lost you around the balance part, I think was the last thing I heard.
Oh, okay. But copyright is a balance between the rights of the creator and the rights of users. Creators have exclusive rights to control the uses of their works and be paid for their efforts, but nobody creates out of nothing. We all, when we're creating things, when we're writing, when we're painting, whatever, even if we're not terribly, you know, we're great artists, and even if we're not wonderful novelists, we are still borrowing from what went before. So it's important that the Copyright Act also provide access to others' works to support innovation and the creation of new works. So if the next slide is in fact an overview of how the Copyright Act works.
Got it.
Okay, and this is not just how Canada's Copyright Act works, it's also how most copyright acts in the world work. You've got, in the first box, you've got folks that are called authors. They're always called authors, even if they're, you know, poets or photographers or cartographers or composers. Also, there are also people who are called performers, makers of sound recordings, and broadcasters who produce what the Act calls other subject matter. And other subject matter includes sound recordings, broadcast signals, and performances. So all those things, works and other subject matter, are protected by copyright. That's in all media, all formats. Copyright protects the products of the human intellect. So for museums, in fact, a lot of your collections aren't protected by copyright. For example, your natural history collections of, you know, minerals, for example, animals, are not protected by copyright because they are not products of the human intellect. Nor are mass-produced objects protected by copyright. So if you have a, you know, Massey Harris Combine in your collection, it won't be protected by copyright because there's hundreds of them. The parts that would be protected by copyright would, for example, be the plans or the drawings, or photographs of Massey Harris combines. But the combine itself, the machine itself, is not protected. So that's one thing that's a little bit different about museum collections, in that a lot of the artifacts, the human-made artifacts and certainly the natural history artifacts, are not protected by copyright, but you still have lots of stuff that is protected by copyright. Now, the Act also sets out who owns copyright, who is the first owner of the copyright. And in general, it's the author, the creator. Whoever created it is the first owner of the copyright. But there are a whole bunch of special rules that are slightly different. For example, one of the most important special rules is the rule that the employer, if you are employed by an organization, say, you are the author, but you do not own the copyright. It's your employer that actually owns the copyright in what you create and produce. So while you may be the author, the employer owns the copyright. And there are a bunch of other special rules that will be, in the workshop that I'm going to be giving at the end of the month. We'll certainly be going into detail on those special rules. So that's, the Act speaks to ownership of copyright. And the Act also speaks, it obviously sets out the rights that the copyright owner owns. And the rights are, for example, the right to copy. I mean, that's what this is called, the Copyright Act. So the right to copy is the one that's fundamental to copyright law. The right to translate, the right to broadcast, the right to perform a play or a piece of music in public. Those are all the exclusive rights of the copyright owner. And if you are not the copyright owner, you must seek the rights holder's permission in order to do those things. Copyright doesn't last forever. On the slide it says, all these authors and other performers, etc., own certain rights for a specified term. And that means copyright doesn't last forever. Eventually it expires. And once copyright expires, anybody can use a work without permission and without payment. The general rule in Canada for the duration of copyright is the life of the author plus 50 years. Now that is going to change as a result of the revised free trade agreement, the new NAFTA. However, Canada has, we have until the end of 2020. Let me do my math here in my head. The end of 2022 to figure out exactly how we're going to implement that. But for the moment, it's still life of the author plus 50. Now, then we get to what are called, what the Act calls exceptions, but what the Supreme Court calls users' rights. And those are exceptions to the rights of the copyright owner, which permit certain uses without payment and without permission. And users' rights are very, very important to cultural heritage institutions, because many of those user rights are what we depend on to fulfill our mission, to preserve our holdings and to make them available in various ways for research or just enjoyment. So the exceptions include fair dealing. You may have heard of fair dealing. The comparable provision in American law is called fair use, but it's somewhat different from fair dealing. So in Canada, it's fair dealing, and the rules are somewhat different from what the Americans do. There's also a whole set of exceptions for libraries, archives, and museums. Remember that I said they were lumped together for the purposes of the Copyright Act. So libraries, archives, and museums have the certain rights to make copies, to preserve their holdings, to make copies for research and private study. And those are the main ones that are of interest to this group here. But the Act actually includes a whole bunch of other exceptions that are of value to private citizens or to other sectors. For example, there's a whole bunch of exceptions that pertain to educational institutions. Now, these exceptions are not, they're not a blank check. They always have limitations or boundaries around them, and terms and conditions. But in the workshop, we'll be going over in great detail the fair dealing exceptions and the exceptions for libraries, archives, and museums in particular. And then, of course, at the very end, if you infringe copyright, in other words, if you do something without permission that only the rights holder can do, then you're said to have infringed their copyright. And if they challenge you on it, and if it's found that you indeed have infringed copyright, the Act provides for penalties. Now, the sorts of infringement that cultural heritage institutions are likely to be involved in are a matter of civil law rather than criminal law. So the penalties for civil law are things like an injunction, like, in other words, stop doing that, get that thing off your website because you made a copy without the permission of the rights holder. So an injunction means, stop whatever infringing activity you're doing. It might be a payment of damages. In other words, how much money did the rights holder lose because you infringed on their copyright, and you presumably got the financial gain rather than them. So no, there's nothing. It's only if you're guilty of a criminal infringement at the criminal level would jail time be involved, or rather large financial penalties, fines, and that sort of thing. So the penalties for civil infringements of copyright are really rather, compared to jail time, rather minor. So that's a very, very, very quick overview of how the Copyright Act works. And I'd like to turn it over to you folks now and go to the next slide and ask you what copyright issues are of concern to you. And if you can just speak in the chat, it's easier than trying to type something out. Or I mean, sorry, if you could just speak using your mic rather than trying to type something out in the chat, that would be great.
I have a question, Anne. I'm wondering about digitizing things and putting them in our database. So if we have a copy of something that's VHS, like an old video, or we have old photos and we want, or documents and we want to have them in our online database, is that an infringement of copyright?
Jean, do we have you?
Yeah, I'm still
Okay.
here. I
Okay.
lost the question in the middle. Yeah, but I think I think I know where the question was going, and I can answer it. So you mentioned you've got VHS videos, for example, and you want to make copies of them. Really for preservation purposes, put them in your database, but not put them online. Am I right?
Yes, that's correct. Although
Yeah.
our database is online.
Oh, okay. Well, yeah. Well, the Copyright Act does include a provision that says you can make copies. I mean, a nonprofit library, archives, or museum can make copies of works that are in an obsolete format or at risk of becoming so. And we know that, VCRs aren't going to be around for much longer. So you can make a copy for preservation purposes, but that exception, that user's right, doesn't extend to making it available.
Darn. Well, it seems like we've lost Jean for the moment again here. It seems to have always kind of circled back around, so we'll just give it a minute here.
On
I'm going to stop the share just for a moment here because it kind of limits my ability to see what's going on. Jean,
yeah, the meeting. Yeah.
Sorry, we lost you there again. We probably lost you around talking about how you can make a copy for preservation purposes if the media is going to be obsolete.
Yes, and that's right. But that exception does not permit you to make it available to the public. So if you're going to put it in your database, essentially you're making a preservation copy to put in your database, and but you'd have to suppress the public access to that particular item.
Thank you. That's helpful.
Yeah, and I also should say there's another little caveat. Remember, I said there were conditions on all these things. If there is a copy in a format, a more current format that you can purchase on the market, you have to buy it. However, if there is no equivalent available for purchase, then you can make the preservation copy. So that's another little, well, like I said, these are not blank checks. But if you're just copying, if you're just copying, if you're copying stuff in order to make it available online, you do, and it's not fragile, it's not in an obsolete format, then you need to be much more careful, because you're what you're doing is, you're communicating it to the public is what you're doing, and that's one of the exclusive rights of the rights holder. Unless, of course, if you mentioned photographs, if the copyright has already expired, which is to say, for photographs, if the photograph was taken before 1949, then the copyright has expired, and you're free to put it online if you wish.
Great, thank you. Does anybody else have a question? Please just feel free to unmute yourself.
One thing that I was wondering about, because we do have a number of art galleries as part of our membership, if you could give us just a brief overview of exhibition rights and how copyright influences those decisions.
Sure. The exhibition right, I'm just going to have to grab my Copyright Act here, because it's not one of the ones I keep in my head. So the exhibition right was added fairly recently. Recently, I'm talking 1988, but which is starting to be ancient history now. Oh my gosh, where? I think I'm losing my mind. Okay. Yeah, so it is one of the exclusive rights of the copyright owner. Well, let me start another way. First of all, the exhibition right only applies to artistic works, which is to say pictures. So that means it applies to photographs, to paintings, to works of art, sculpture, but it doesn't apply to text like diaries or letters or that sort of thing. So it only applies to works of art. And you mentioned you're a gallery that has works of art. And it only applies to works of art that were made before June 1st, 1988. Sorry, I am just going mad here trying to.
Don't worry too much, it's okay.
No, but it's just, and I'll go from memory, which is not always a good idea. And what the right is, the right to exhibit in public. So in other words, if it's in your house, you don't need anybody's permission. But if you're displaying it in a gallery, for example, then the artist, you need the artist's permission to do that, and the artist will probably want payment of a fee, and the act doesn't say how much the fee shall be, or even that there has to be a fee. But of course, the whole point of copyright is that creators deserve to be compensated for their works. And so they are very likely going to charge a fee. CARFAC has come up with which is the an artist's collective society. They've come up with a schedule of exhibition fees that you probably would be asked to pay. The other thing I will say is that, yeah, thanks, Sam, for putting that in the chat, that it's only artistic works made before June 1988, because they didn't want to make it retroactive. They made it, going forward. So it's quite limited in scope. The other thing that's excluded from it is our maps and plans, because of course there are maps and plans all over the place, like the fire exits in your building is a map that's protected by copyright. That sort of stuff, nobody wants to pay to have to display the exit routes or the fire routes. So those are excluded from the exhibition right. Sorry, that was awfully disjointed. Does it make sense, or do you want me to go over anything?
I think it makes sense to me. I'm just curious, just more from a personal perspective, just because I've been involved in exhibitions and that sort of thing previously. So just kind of bouncing off that. So say, for example, a gallery holds work in their permanent collection, and then they decide to curate it into an exhibition from their permanent collection. Are they then required to pay the artists the fee because they're displaying their work?
Yes, well, first you need to ask permission, because that particular exception sets out what the exclusive right of the artist. So you'll ask permission, saying we are going to display your work of art in our upcoming exhibition. May we have your permission to do so? And the artist will probably come back and say, well, yes, but subject to payment of a fee of such and such.
Right.
So it starts with the permission, and then the fee comes in.
Right. Okay. Now, one more question on that, and I won't take everybody's time, but I'm curious now. So then if let's say the artist is deceased and maybe they don't necessarily have an estate, is there anything that's required beyond that? Or, yeah, kind of getting into the nitty gritty, but I'm curious.
Yeah, well, copyright, remember when I was talking about the term of copyright, how long does it last? The general rule is it lasts for the life of the author plus 50 years. So obviously, for that 50 years after the author's death, somebody owns the copyright. Now, it probably would be, if you're really, really famous, like, Picasso or something like that, then obviously the estate is going to be, you'll know who the estate is. But in general, it would, if an artist, say, has not made provision for, say, some special executor to administer the rights in the works of art, then it probably would be the family. So you might have to do a little bit of digging to try and find out, see if you could track down the will and who the heirs are. And it would be them that you would contact.
Interesting. Thanks.
And if, well, a lot of copy, say you can't track them down, you have no clue, but you've tried. So keep any records of your search, even though it was unsuccessful. And then it becomes a matter of your institution's tolerance for risk. Some institutions are, they would put a higher priority on getting the stuff out there than, and they would consider the risk low if they've tried and failed to find out who the current rights holder is. So some institutions might go for it and use it. Other institutions might be very averse to risk, and they don't, they would choose another piece of art, for example, or not use that one anyway, because they're more worried about a rights holder popping out of the woodwork, even though they had tried and unsuccessfully to find that person. The Act, needless to say, does not say anything about tolerance for risk. That's an institutional decision about what the institution is prepared to tolerate in terms of risk. So does that sort of close the circle?
I think so. Anybody else have any copyright questions for our copyright expert right now? It's a good chance.
I have another question about museums displaying artworks that have been given to them. So I was under the understanding that if you purchase a work of art, you often purchase the copyright as well. And so if you gift that then to the museum, we are getting the copyright from you when you sign your transfer of ownership. So then we would have the right to hang that work of art in our museum. Is that correct?
I think we may have lost you again there for a minute, Jean. Let's see. I can't hear you.
Okay.
Oh dear. Oh, there we go. Got you back.
Yeah, got me back. Yep.
Yep. Oh, and maybe not. OTech. We'll just try and give it a minute here and see if it comes back around.
Technology is wonderful when it works. We'll work on getting this sorted out before the big training event.
This is an amazingly weird connection.
Yeah.
Yeah, you don't, as I was saying, you don't, when you buy a work of art, you don't automatically get the copyright along with it. You have to address the copyright explicitly in the sale agreement. And similarly, if you're donating a work of art to a gallery or a museum, same thing, the copyright has to be explicitly addressed. You may indeed also own the copyright in it, but the copyright doesn't automatically follow with the physical item. And certainly, it makes life easier for the museum if you can convince the artist to gift the copyright as well as the physical thing, because then the museum will own the copyright and doesn't have to ask anybody for permission. But copyright and does not and the physical item do not. They're two separate things and have to be dealt with separately in any acquisition transaction.
Anybody have any other questions they'd like to ask?
The other thing, of course, is it's possible for a rights holder to assign their copyright to someone else, either through sale or gift. But another way to authorize use would be to grant the museum a license, for example. The artist would still own the copyright, but the artist could grant the institution a license to display it, to copy it and digitize it and put it online. If it would be a matter of negotiation with the donor.
Great. If anybody else has any questions, please feel free to unmute yourself and jump in. We'll give you a moment. Okay.
Yeah, I noticed that Vincent has has added some knowledge to the chat about the Carfax fees. So that's good to know.
And just going while we give folks a minute here, I'm just going to put some links in the chat here. We've got. So I've put in, of course, our links to our upcoming and past community chats. We're always looking for people to present. So if you want to present at a community chat, there's the call for presenters there. And then I also put in the fall 2021 courses and programs link, where you'll find the links to all the courses I spoke about in the intro there. Well, thanks, Donna. Thanks for joining us. All right. Well, I won't keep folks if there's no additional questions here, but I'd like to thank Jean for your presentation. I think we managed through despite a few technical difficulties, so thanks for your patience with that.
Yeah, and I'm sorry for, well, who knows what's going on in tech land, but I apologize if it was any of it was my doing, but it's very weird.
Always out of the person's control, and it always happens when you least need it to. So don't worry.
Well, that's true. But I would like to thank you for your attention and your comments and your questions. And I think if you go to the very last slide, there's a link to a link that allows you to register for.
Sure, I'll put it up here. Let's see, I'll just skip the link here. Just give me a second here, folks, and I will put the direct link in.
Yeah, it's on September 27th and 28th. It's in two parts, and in the afternoon. For those of you that don't think you could stand a whole day of copyright, 2 half days may be more palatable. I think copyright's enormous fun, but I don't think it's a view that's necessarily widely shared.
important though. Maybe not necessarily
Yes.
fun, but you should be aware.
Yeah, and
Yeah.
I try to make people, I mean, we will have some laughs because if you can't make things funny, nobody's gonna, I mean, copyright, I always have, it's a challenge for a presenter about copyright because people have very low expectations. But so people are always surprised when they turned out it was more fun than they thought, and they learned a lot. So I look forward to seeing many of you at the end of the month.
Yeah,
Great.
and that's what, because when I've looked at copyright, it just makes my brain warm. I didn't even bring up the concept of moral versus economic rights, because I figured you'd deal with that later.
Well, we will be talking about that. But do you want me to give you the quick answer now? The economic rights are the rights that can be exchanged for money, like the right to copy, the right to broadcast, the right to translate, the right to publish. Moral rights, however, always belong to the author. The economic rights can belong to the author, or as I mentioned in that example, for works created in the course of employment, it's actually the creator, or sorry, the
Oh dear.
Yeah, but you can transfer the economic rights, but you can't, that the creator can transfer the economic rights, as Jean said in that earlier example, but the creator can't give up their
employee.
moral rights.
There we go.
Yeah, there. Yeah, the moral right.
Well, Jean, I think our connection's getting steadily worse here. So I think we'll have to leave it at that. And I don't know if you can hear me or not, but thank you very much. And I hope that folks will take a moment to have a look at the course that's coming up. I think it's going to be really useful for museums and galleries of any size. So yeah.
There,
Great.
I'm back now. Anyway,
Okay.
we'll save the moral rights for the workshop. But thanks so much
Okay.
for the opportunity, and see you at the end of the month.
Awesome. Thanks very much, everybody. Thanks, Jean.
Thank
Okay,
you.
bye-bye.
Bye.